Assalamualaikum warahmatullahi wabarakatuh. My name is HUMAIRA binti NIZAM and my metric number is 1231639. Today, I will be presenting the first part of our article review, focusing on the basic information and the introduction of the study. So, the article is titled Amalan Pengurusan Sulh di Jabatan Kehakiman Syariah. This paper is co-authored by 3 researchers, Associate Professor Hadinan Topet and Ahmad Shah Afandi from the Academy of Contemporary Islamic Studies, UiTM Sarawak, alongside Professor Zainuddin Hudi Prasojo from the State Islamic Institute of Pontianak, Indonesia. This study was published in the Journal of Syariah Law Research, JSLR 2023, Volume 8, Issue 1, spanning page 1 to 32. Looking at the key dates, the manuscript was received on February 16, 2023, accepted on June 21, 2023, and officially published on June 30, 2023. The core themes of this research are categorized under the keywords Alternative Dispute Resolution ADR, Islamic Law, Mediation, and Sulh. Now let's move to section 1, the introduction. As a background to the issue, human life is naturally intertwined with conflicts, particularly within family institutions. Domestic crises and post-divorce disputes can heavily destabilize households and inflict psychological harm on children. However, in Islamic jurisprudence, formal court litigation is not the only option, which is sulh or mediation serve as an amicable alternative to resolve these matters peacefully. For the problem statement, this paper focuses on a specific case study at the Department of Sarawak Syariah Judiciary, DSSJ, Kuching Division, covering the years 2014 to 2020. During this period, there was a dramatic surge in post-divorce claims such as maintenance and matrimonial property, which heavily burdened the Sharia courts. Making the situation worse was a critical shortage of human resources. The Sulh unit there was operating with only 2 qualified officers. The authors also highlighted a notable gap in contemporary literature regarding localized Sharia court operations and this specific administrative challenge. To address the issue, the study outlines 3 specific research objectives. First, to analyze the core definitions and historical practice of sulh in Islam. Second, to assess the implementation of the sulh session known as Majlis Sulh and DSSG Kuching. Third, to evaluate the structural and administrative constraints faced by the sulh unit. Finally, looking at the methodology, the researchers adopted a qualitative approach. Data collection was done through 3 methods: library research, semi-structured interviews, and document analysis. This data was then analyzed using inductive, deductive, and comparative frameworks. All these elements establish a solid foundation for the rest of our review. That's all from my part. Thank you very much.
The article entitled Amalan Pengurusan Sulh di Jabatan Kehakiman Syariah discussed the practice of sulh management at Sarawak Syariah Judicial Department (JKSS), particularly in Kuching Division. This article begins by explaining that disputes and conflict are a natural part of human life. Therefore, sulh serves as an important alternative dispute resolution mechanism because it provides a faster, more efficient, and less confrontational way to resolve dispute compared to court litigation. From an Islamic perspective, the concept of sulh is based on Quran and Sunnah, particularly Surah An-Nisa and Surah Al-Hujurat, which encourage reconciliation, peace, and justice among disputing parties. The study also explained the jurisdiction of sulh in JKSS. Sulh is applicable to family-related disputes such as maintenance, child custody, and mut'ah claims. However, it does not apply to cases involving marriage dissolution, verification of lineage, and faraid matters. In terms of implementation, the sulh process follows the sulh work manual and court practice direction. Sulh officials are required to uphold important principles such as confidentiality, equal opportunity for both parties, fairness, and compliance with Sharia principles throughout the mediation process. Finally, this article highlights several challenges faced by JKSS. The main issue is the shortage of qualified sulh officer, which result in heavy workload and limited time for handling cases. In some situations, Sharia judges are required to perform the duties of Sulh officer, but this is considered less effective because it provides specialization and may affect the credibility and efficiency of Sulh process. This article shows that Sulh is an effective and Sharia compliant method of dispute resolution. However, its success depends on having sufficient trained officer and a well-managed implementation system.
Today, I will present the key findings of the article on the practice of SULO and the role of SULO officer in dispute resolution. The article emphasized that professionalism is one of the most important qualities of SULO officers. They must have strong communication, counseling, and physiological skills to manage different personalities and emotional situations effectively. The success of the Sula process also depends on the cooperation and willingness of both parties to reach a mutual agreement, as well as the competence of the Sula officer in facilitating this discussion. However, the process may be affected by challenges such as limited human resources, heavy caseloads, and social and financial factors. The article also recommends strengthening the professionalism and specialization of solo officer through continuous training and better human resources development. These improvements can enhance the quality and efficiency of the solo process. In conclusion, solo is an important Islamic alternative dispute resolution method that not only reduces the burden of the court system but also promotes peaceful, fair, and harmonious settlements. Its effectiveness ultimately depends on the cooperation of the parties involved and the professionalism of the solo officer. Thank you.
My name is Dianah binti Abdul My number metric 1231550. Now, I would like to present the critical analysis of this article. Firstly, one of the main strengths of this article is that it provides a comprehensive discussion on the implementation of Suluh as an alternative dispute resolution or ADR mechanism in Sarawak Syariah Judiciary Department. The author successfully combines Islamic principles from the Quran and Sunnah with modern Sharia court procedure. This shows that Suluh is not only a legal process, but it is also an Islamic approach that encourages peace and reconciliation. Instead of creating conflict between the parties, Suluh aims to achieve a win-win solutions through mutual agreement. In addition, the article clearly explains the definitions, pillars, and conditions of suluh, making it easier for reader to understand the concept. Secondly, the methodology used in these articles is another strength. The author supports the discussion by using statistical data from 2040 to 2020 and several real case studies which make the findings more objective and relevant. The analysis shows that the success of suluh mainly depends on human factors, especially the willingness of both parties to attend decision seasons and to compromise. However, the article also points out that many suluh season fails because one or both party do not attend without a valid reason. This shows that even though the solo system is well established, its effectiveness still depends on public awareness, cooperation, and the commitment of the parties to resolve their dispute peacefully. That's all from me. Thank you.
Ini binti Zairul AZMIR, my metric number 1231582. I will continue to another critical aspect raised in the article is the human resources and logistical constraint in the Sulh unit of JKSS Kuching Division. Here explained that only 2 Sulh officers are responsible for handling a large number of cases. They are also required to conduct Sulh session in other divisions due to the lack of qualified officers. This situation increased their workload, causing delay in case management and affecting the quality of service provided. In addition, the practice of assigning Syariah judge to act as Sulh officer may reduce the level of specialization need to ensure an effective and professional Sulh process. The article also points out a weakness in the legal framework in Sarawak. At the time of study, the Sarawak Civil Procedure Sulh rules had not yet been gazetted and were still in draft form. Without clear legal rules, the Sulh process may not be carried out consistently. An officer may face difficulty in following standard procedure. Therefore, the writer stressed that these rules should be gazetted as soon as possible to improve the management of Sulh cases and provide clear guidance for officers, lawyers and disputing parties. Overall, although the Sulh system in Sarawak has been effective in resolving disputes, it still needs improvement in staffing, funding and legal support to ensure its long-term effectiveness.
My name is SYAZWANI binti SURIZAL. My metric number is 1231555. So next, I will present about personal reflection on this article. After reviewing this article, we gain a better understanding of the concept and importance of Sulh as an alternative dispute resolution method in the Syariah judiciary system. One of the key lessons I learned is that Sulh is not just a mediation process. It is based on the principle of the Quran, Sunnah, and Islamic law, which is emphasize justice, reconciliation, and mutual agreement between the disputing parties. And we also realize the significant role of the Sulh officer. Besides acting as a natural mediator, the officer must possess strong communication, negotiation, and conflict management skills to help both parties reach a fair settlement. In our opinion, the Sulh process is beneficial because it saves time, reduces costs, and lessens the workload of the Syariah courts. However, its success depends greatly on the willingness and cooperation of both parties to resolve their dispute peacefully. Overall, we believe that greater public awareness of Sulh should be promoted so that more people understand its benefit and importance in resolving family dispute. Finally, I would like to conclude our presentation. In conclusion, this article successfully explained the concept, principle, and implementation of Sulh within the Malaysian Syariah judiciary system. The study showed that Sulh is an effective alternative dispute resolution mechanism, especially for family-related cases, and is encouraged peacefully settlement without lengthy court proceeding. Furthermore, the effectiveness of Sulh depends on several factors, including the cooperation of the parties involved, the competency of the Sulh officer, and a well-structured legal and administrative framework. So overall, Sulh play a vital role in promoting justice, harmony, and efficiency within the Syariah legal system. Therefore, continuous improvement and greater public awareness are essential to strengthen the Sulh institution in the future.